Yes, Mr. Hare, point 3.
Yes, thank you, my lord. So point 3 was to use the Gillick authority as a way of demonstrating, as it were, how it's possible for a challenger to ensure or provide the legal element which must underlie a challenge to these kind of documents. The account of Gillick, which is given in the A case, is quite a full one, and I'm going to invite the court to look at parts of it if I may.
Yep.
So in the authorities bundle, the case of A begins at it's tab 19, page 710, and I'm inviting the court to look, please, at page 724, where the court should see, so that's 724, paragraph 29, and above paragraph 29, the heading Discussion, the test for judicial review of a policy at common law, the Gillick principle.
Yeah.
And the analysis, as it were, the discussion referred to there, really begins at paragraph 30, setting out the background to the Gillick case. I'm not going to set that out. I know this court is extremely familiar with what the Gillick case was about.
Yeah.
What I did want to show the court, though, was as an exhaustive analysis of Gillick. Gillick is found to be the correct way of stating the test, which is then reformulated in A. But the 2 points I wanted to show your lordships, to make good, if I can, my third point, begins at paragraph 31, where the Supreme Court looks at the judgment of Lord Fraser, who was a member of the majority who upheld the guidance which had been issued by the Department of Health to health authorities as lawful. And Lord Fraser there identified, it's set out in the first line, set out a series of conditions to be met for a doctor's decision to give contraceptive advice and treatment to a girl under 16 without informing her parents to be lawful. And the key legal element, as it were, I've referred to it as the legal hook. It's not a very pleasant phrase, but I've used it now. So the legal hook upon which to hang the challenge, as it were. Yeah. It's not a very decorous phrase, but I've used it now, so I'm going to carry on if I may. Yeah. We can see there are two hooks in the Gillick case. The first is that identified here in the discussion of Lord Fraser's judgment in the House of Lords. And I'm looking between the letters C and D, where it's referred to the fact that Lord Fraser observed that, as had been common ground in the Court of Appeal, whether a doctor who followed the guidelines in the policy would commit an offence contrary to Section 28 of the Sexual Offences Act 1956 by aiding and abetting the commission of unlawful sexual intercourse would depend on the circumstances of the case. So there's the law in relation to that part of the challenge to the policy in the Gillick case. Section 28 of the Sexual Offences Act 1956 and the law, the common law of aiding and abetting. That was how it was analysed by Lord Fraser. When one comes on to look at the dissenting judgments, and in particular Lord Templeman, we see that there was a different formulation of what the legal hook was. And we see that beginning at paragraph 37. So I'm now all the way down on page 727, my lords. Paragraph 37 begins with a reference to Lord Brandon's judgment, who was also in the dissenting group of judges, Lord Brandon and Lord Templeman. But then I think 5 lines down by letter H, I hope your lordships can see Lord Templeman's view. Yeah. Lord Templeman's view is that a girl under 16 is not competent to agree to medical examination and treatment. He considered the guidance was unlawful in stating that it was a matter for the clinical judgment of the doctor to prescribe contraception without the knowledge or consent of a parent, whereas that would constitute an unlawful interference with the rights of the parent. And of course, this was an era in which the rights of parents were discussed as rights and as being legal rights. And so the two hooks in the Gillick case, as it were, that gave substance to the challenge, the legal hooks, were there both in the criminal law, in that provision of the Sexual Offences Act, and in the private law, rights of the parent to be informed if one of their children was going to be given that advice. Now, the challenge failed, of course, a majority of 3-2 in the Gillick case, but it doesn't alter the fact that the court was very clear and Gillick is cited in A as being the guide to the common law's approach to challenging these kind of policies, that there must be some legal basis for the challenge, some positive law which provides the hook upon which you hang the challenge. Now, of course, that can arise in any number of different ways in relation to a policy, and could possibly have arisen in relation to good medical practice. There can be procedural challenges brought because there's been a lack of proper consultation, say, or a failure to take account of a relevant consideration, such as the public sector equality duty. But then it's the common law of consultation, the common law requirements of natural justice, or procedural fairness as it's more often called now, that provides the legal element, or it's section 149 of the Equality Act, which sets out what the public sector equality duty is and makes it a mandatory relevant consideration in relation to the formulation of policies which may have an impact on matters relevant to the Equality Act's provisions. Equally, there could have been a legal reason why to bring it back. I mean, and there is no challenge on that basis, no challenge on the basis of consultation or public sector equality duty here. There could have been a legal reason why good medical practice was unlawful if it actually said, as an associate professional, introduce yourself to patients as a medical practitioner or as a registered medical practitioner, then that would be a legal hook on which the BMA could hang its challenge. Because we know that registered medical practitioner is a protected term under the Medical Act, through the Health Act and the other provisions that my learned friend took the court to, or if it said to associates, feel free to describe yourselves as registered under the Medical Act. That would provide a sufficiently clear and legally defined basis for a challenge based on what my learned friend calls misdirection of law.
So that your hook there would be section 49.
Precisely, yes. That's the legal hook. But section 49, nor the Health Act, nor any of the Interpretation Act, has anything to say about the term medical professionals. It's not a legally defined term in a way which makes its use by the GMC, especially in a document like Good Medical Practice, unlawful. We say there is no general ground of judicial review called misdirection in law. You have to demonstrate, well, first of all, you have to demonstrate that there is a misdirection in law. And that's the fourth point, really, is that it's the law element that's missing from my learned friend's submissions on misdirection in law. Words take their meaning from their context, and you cannot get, as a matter of the ordinary principles of interpretation, we say, from the fact that the medical profession is used as an undefined term, but is referred to in the Medical Act, to an argument that it is therefore unlawful to use a different term, medical professionals, to describe in good medical practice a different group of people regulated by
Sorry, just
General
say that
Medical
again.
Council.
You can't get from medical professional.
So what I was saying, so this is my fourth point about where the law might be, my lord.
Yeah.
As your lordship said, the legal hook could be in section 49.
Yeah.
But where it can't be is because there you've got a specific concept, registered medical practitioner, something of that nature. Sorry, my lord, if I'm repeating myself.
Yeah, no.
What you can't fill that gap, as it were. You can't provide the legal hook by saying that just because the term medical profession is used in the Medical Act 1983 in a way which clearly refers to doctors, of course it does. That's what the Medical Act's about. The GMC didn't regulate anyone else in 1983 when the Medical Act was passed. But it's not, medical profession is still not a defined term in the Medical Act. I keep emphasising that, I know. But I'll try not to say it again. But you cannot get from the fact that that term is used in the Medical Act to the proposition my learned friend advances as a ground for her legal challenge, that in a completely different context, which isn't a legal context at all, which is ethical guidance, the GMC is precluded from using a different term, medical professionals, where that term is explained in context, as we've seen in page 295 of Good Medical Practice. It's used a limited number of times, not in relation to the matters which create an obligation, and it's explained as simply a convenient shorthand or umbrella term for the three professions which are regulated by the GMC now as a result of the order. So that's the fourth point. The fifth point is there is also in Gillick, approved by the Supreme Court in general guidance about how a court approaches, no, I've not put that well. There's guidance about how a court should approach guidance. So there are indications from the court in Gillick which are approved by the Supreme Court in the A case, which set out some principles which should guide a court when it's looking at guidance. Guidance like good medical practice. Some of it's very obvious, but I would just like, if I may, I hope the court is still in around paragraph 30. If one looks there in paragraph 34, we see a quotation from Lord Scarman. Lord Scarman was explicit. It was not the role of policy guidance to eliminate all uncertainty regarding its application and all risk of legal errors by doctors. It was to be read objectively, having regard to the intended audience. So they're the first two principles. To be read objectively, having regard to the intended audience. And then, if we look to the bottom of that page, 2 lines up from the bottom, there's a sentence beginning, contrary to a submission made by Mr. Southey. Contrary to the submission made by Mr. Southey, the drafter of a policy statement is not required to imagine whether anyone might misread the policy and then to draft it to eliminate the risk. And then at 40, in a passage, so that's the second, as it were, principle. You read it objectively, you have regard to the intended audience. As I mentioned before, here it's doctors and associate professionals. And the drafter is not required to imagine whether anyone might misread the policy and then draft to eliminate the risk. And then at 40, the fourth principle, which my learned friend also read out, which is towards the bottom of page 728, in a quotation that goes over the page, but 4 lines up from the bottom. Also, if the test were of the nature of which Mr. Southey contends, the courts would be drawn into reviewing and criticising the drafting of policies to an excessive degree. And then I would just invite the court to read the rest of that paragraph, if I may, which talks about, we say, how inappropriate it would be if the court is drawn into a revising role in relation to policies, which goes beyond the matters upon which the court, of course, legitimately brings its own expertise to bear, that is to say, the meaning of legal terms. And the final element appears at the bottom of paragraph 42. So this is the fifth general principle, as it were, to be applied when looking at policies, and that is you read them as a whole. And it says there in paragraph 42, page 3950 by letter E, contrary to Mr. Southey's contention, when reading the guidance as a whole, no part of it can fairly be construed as giving a misleading direction. And that, reading the guidance as a whole, is crucial to consideration of good medical practice, because I've alluded to this before, but can I just make it good by showing the court the reference, please? So if the court would be good enough to turn back to the core bundle, Good Medical Practice, beginning at page 293, and look, please, sorry, I do apologise, I may have given the wrong page reference there. I'm looking at page, 314. Yes, it is the version. Obviously, there are two versions next to each other. I'm sorry, I'm confusing myself about which is which. But this is the one we've been...
the December.
Yes, this is the December one.
This is the December one.
Yes, and on page 314, there's a heading, Acting with Honesty and Integrity. So here again, we see what I referred the court to previously. The introductory section refers to good medical professionals. And then we see reference here to the actual rules. You must make sure your conduct justifies patients' trust in you and the public's trust in the profession. 82 is the crucial one, both sentences. You must always be honest about your experience, qualifications, and current role. You should introduce yourself to patients and explain your role in their care. So far from my learned friend described as good medical practice giving associate professionals carte blanche to describe themselves as a medical practitioner or in any way that they think is appropriate. The actual rules couldn't be clearer about what the ethical obligations of associates and doctors are. And that point about you look at the audience is crucial. So we've looked at one of the audiences, and my learned friend identifies two audiences really, I think, that she's mostly concerned with, and where she says this misdirection in law is potentially relevant. One is associate professionals who she says may go off as a result of reading GMP and start describing themselves as medical practitioners or otherwise giving the impression that they're registered under the Medical Act. And then patients. So we've been looking at to whom is good medical practice addressed, and it's addressed, as we know, to doctors and associate professionals. In terms of the public and public confusion and the guidance that was available at this time and guidance that's available now, if a patient is concerned about a medical professional who's treating them or with whom they've had contact, it's perfectly open for them to look. And this is referred to by Mrs. Justice Lambert, and of course she was shown it previously, on the GMC's website at the time, and we have the pages from the website at the time. There are equivalent pages now which are referred to in a footnote to our skeleton argument. But if I could just show the court briefly the relevant parts, please, of the guidance. So it's in the supplementary bundle, beginning on page 301. So this was published on the internet. It's just a printout of the pages. It was published on the 24th of October 2023. It's headed More Information on PAs and AAs. I'm not going to read it all out, but if I can just point the court to a few relevant paragraphs. The second paragraph, PAs and AAs are distinct professions. They are not doctors, and professional guidance expects them to always make that clear to patients and colleagues. PAs and AAs should never be referred to as medical practitioners, because that term is used specifically in legislation to mean doctors. It then says something about the training that's received by PAs and AAs. And then if I could invite the court please to go down to page 307. It's in the same, I call it a document, but it's all printed off the same document. 307 has a heading towards the top, how PAs and AAs describe themselves. It repeats, PAs and AAs are distinct professions, they are not doctors. As regulated professionals, PAs and AAs will have responsibility to clearly communicate who they are and their role in the team, just as doctors must do now. And there's a reference then to the relevant parts of the guidance, which I've shown the court in a later iteration. And then there's a reference to guidance on titles and introductions from the Faculty of Physician Associates, and a link is there provided. and provides a structured and standardised way of using the physician associate title and highlights the importance of explaining it. It goes on to emphasise if someone is falsely using a protected title or implying that they're a licensed doctor when they are not, we have powers to act. And this obviously, as I said, is a general document which anyone looking up the GMC's website, looking perhaps for good medical practice, would be able to find very straightforwardly. Indeed, they'd be taken to this document before they were taken to good medical practice. The names of the professions, we have no remit over job titles. The terms physician associate and anaesthesia associate came into use in the UK some years ago, and the Department of Health and Social Care intend to legislate on that basis to make these protected titles. That's what we know was the intention, indeed carried out. Perhaps I could just ask the court please to read the rest of that page, down to future format of the register and GMC numbers.
Yeah.
Thank you, Lord. We say if those 5 propositions are sound, that's a complete answer, at least to ground 1A and B, in the submissions which have been advanced by my learned friend. As it were, the underlying, I think it's what your Lordship described, my Lord Justice Coulson described as the underlying basis, was it, for ground 1? Yes. Yeah, so if we're right about that, then ground 1 in essence falls away for the reasons I've given. But I'm going to say a word about ground 1B, if I may. That is to say about the classification in A, because my learned friend has, as she did below, although she criticises the judge for using the classification in A in analysing the policy, it was part of my learned friend's case below. And you can see that from the skeleton argument which we have in the core bundle, that if she needed to, of course my learned friend said she didn't need to, but she said if she needed to, as she said to this court today, then she does fall within the classification in A, that is to say under ground 1 and ground 3. Yeah. We say that's simply not sustainable when one looks at what A says about ground 1 and ground 3. And I could deal with it very quickly because it all relates to the points I was making a moment ago. But if the court would be good enough just to turn back to paragraph 46 of A, authorities bundle, sorry to keep moving between them, but authorities bundle, page 731, paragraph 46, which I know my learned friend has taken the court to already. And the overarching point, perhaps, sorry, I've lost my own reference now, in 46, yes, is we only need to look, as my learned friend relies only on 1 and 3. Mm-hmm. The first one, of course, where the policy includes a positive statement of law. So that's, again, where the need for the legal hook is fatal to my learned friend's case. There has to be a positive statement of law which is wrong. Use of the term medical professionals in good medical practice does not constitute a positive statement of law. It's not a statement of law at all. There are no statements of law in good medical practice. It's not that kind of document. And it's not enough, I heard my learned friend use the term twice, if it permits an associate or other person to misdescribe their profession. It must induce, and this was one of the difficulties that the Supreme Court identified with some of the cases following on from Gillick, which interpreted will induce as will induce or permit. And the Supreme Court was very clear, permitting is not the test. It must induce, will induce a person who follows the policy to breach their legal duty in some way. Now, the only legal duty that could be relevant here is the Section 49 duty that we've been referring to. You have to look, as we know from Gillick, at good medical practice as a whole. It's simply not arguable, we say, that anyone reading good medical practice as a whole would think that they were, by the use of the GMC's, by the GMC's use of the term medical professionals in those limited areas, that they were entitled to describe themselves as either a registered medical practitioner or as a practitioner registered under the Medical Act. Because you look at it as a whole, and it's very clear. It has to be, this is the bit of good medical practice that's challenged, the references to medical professionals. That's the positive statement of law my learned friend has to rely on, and it's that has to induce the person who follows the policy as a whole to breach their legal duty in some way. So we just can't get off the ground. 3, where the authority, though not under a duty to issue a policy, decides to promulgate one, and of course you can get that far with this because although the GMC is under a duty to issue guidance in relation to the associate professions, it has a discretion in relation to doctors, as we saw from Section 35, which my learned friend showed the court, and again, which is in Mrs. Justice Lambert's decision below. But where it decides to promulgate a policy, and in doing so purports in the policy to provide a full account of the legal position. There we are again, there's the legal hook that's required. It's completely absent in our case. The legal position. Even then, it would have to be a full account of the legal position. Now, what that would mean in this context would be a full account setting out all the different protected titles and all the different ways in which it was lawful or unlawful to use those different titles. In other words, it would be saying you can use this title, you can't use that title. That's not what good medical practice is about.
You're saying it doesn't misstate the law either.
No, exactly. It doesn't state the law at all. Because medical professionals is not a legal term. On that basis, we say that the learned judge, in her judgment at paragraph 82 to 83, where she goes through the elements of A, applying them to the facts of the BMA's challenge and good medical practice, the judge's approach was unimpeachable. And we addressed that in our skeleton argument, paragraph 73 to 74, so I don't need to say any more about it now. That's ground 1B. Ground 1C, again, just falls away if we're right in our 5 propositions. And in any event, Padfield and irrationality are really the basis of ground 2. So I'm going to move on to ground 2, if I may now. I'm going to start with Padfield. And there are really 2 halves to what I want to say about Padfield.
So this is.
So I've moved on to
sorry
ground.
sorry to be dull, but I'm a big believer in headings. Yes. Ground 2 underlined. Point 1.
Yes.
Padfield.
Yes. Point 1 Padfield.
Yep. Underlined.
And under that heading, maybe perhaps a dotted line. Sub 1. What Padfield properly applied means in this context. That's the first point I'm going to address.
Yeah.
And then I'm going to address head-on what my learned friend says about how the GMC stuck with the term medical professionals even when it became clear that Parliament wasn't proposing to proceed with that term in the order. But I want to explain Padfield itself first, very briefly. So what does Padfield require and what does it mean in this context? Well, the court's very familiar with the law. My learned friends referred to it. You have Padfield at Authorities Bundle 10. Tab 10 of Authorities Bundle. It begins at page 389. It's the judgment of Lord Reed that everyone relies on, and it's at page 418. And can I invite the court just to look at it very
of course, 418.
please? Yes, so it's Authorities Bundle, page 418 is where the judgment of Lord Reed begins. And the crucial passage, which is so often referred to and which is now regarded as it were, the Padfield test, is at page 422, sidelined, and it really begins on the fourth line down. Parliament, can I just invite the court to read that? Parliament must have conferred the discretion to the end of the paragraph, please.
So 422, letter.
Between B and C, 4 lines
Parliament
down
must,
from
yep.
Parliament must have conferred,
Yep.
yes.
Yeah.
So 2 crucial points, perhaps commonplace, but first certainly a commonplace. The policy and objects of the Act. So the starting point is to identify what the policy and the objects of the Act are. And you, in order to do that, you construe the Act as a whole. And that, of course, is a function for the court. So the first point is construe the Act as a whole. And then you get to the test. If the minister, by reason of having misconstrued the Act, or for some other reason, uses his discretion, in this case the GMC's discretion, so as to thwart or run counter to the policy and objects of the Act, then our law would be defective if it didn't acknowledge that as a ground of review. So that's the process I'm inviting the court to look to now. That is to say, the statutory purpose of the MA as a whole and the AAPA order. I can deal with the start of that very quickly because we say, and I don't think there's anything between the parties here, the purpose is very clear. It's to protect the public as broadly defined in the Medical Act and in the order, and to do so by subjecting the associate professions to the same rigorous standards that are applied to doctors through the same regulator, the GMC.
Yeah.
And you can see that, I'm just going to give the court the reference. You can see that from, of course, my learned friend showed the court already, section 1 large A and 1 large B in authorities, tab 1, page 20 to 21, but precisely the same interest, overarching objective, is identified in the order at page 277, again obviously in the authorities bundle. And I wonder if the court would be good enough, please, just to turn that up. So we're in the order here.
Yeah, we looked at it. Paragraph 3, I think.
Oh, I'm sorry.
That's right. No. It's Schedule 1,
Yeah.
and it's paragraph 3.
Yeah, and the reason I wanted just to spend a moment longer on it
Yeah.
is because the GMC is obviously referred to as the regulator here, but the regulator says, in addition to its objectives and duties set out under section 1.1a and 1b of, and paragraph 9a, 1b and 2 of the Medical Act, has the objective of promoting and maintaining, and then it sets out 1 and 2, the public confidence in and proper professional standards and conduct for members of. In other words, it is the same because of the way the order incorporates what's in the Medical Act about that overarching objective. So that's relevant too, as of course is the fact that they're being subjected to the same regulator in any event. More specifically, in relation to performance, conduct and ethics, which is what good medical practice is, it's the GMC's guidance in relation to those matters. The court has seen already section 35 of the 1983 Act, which provides the GMC with the power to issue standards of professional conduct, performance or medical ethics. I'm not going to take the court back to that, page 83 in the authorities bundle.
So, sorry, which section was that?
Oh, sorry, section 35.
Yeah, that's right. Section 35 of the Medical Act.
That's correct.
Yeah.
My learned friend took you there.
Yeah.
It provides a power to provide in such manner as the GMC shall consider appropriate guidance on those matters, standards of professional conduct, performance and medical ethics. Now there is a difference between the way that's expressed in the Medical Act and the way it's expressed in the order, and I've already referred to this, because in the order, the regulator, being the GMC, has a duty to determine the standards applicable to associates. And that's in, on page 264, I do apologise, in part 2 of the order. So Article 3.1, the regulator must determine standards applicable to associates. The standards must relate to, includes a number of different matters, but also C, performance, and D, conduct and ethics. So conduct, performance, and ethics, the matters which were also in section 35 of the Act. So the powers and duties of the General Medical Council is to produce guidance in relation to those matters which help it to achieve or are in pursuit of its overarching objective of the protection of the public, as defined in the same way in both provisions. There is nothing in the Medical Act which limits what those matters can cover or the standards which will be enforced by the General Medical Council, save, of course, where those ethical duties overlap with legal requirements. And certainly there is nothing in these empowering provisions of the Medical Act which provides any limitation on the use of collective terms to describe the professions now regulated by the General Medical Council. The view must have been taken that the best way to advance the protection of the public was to subject associates to the same regulator and structure as doctors, and that that regulator should be the expert and experienced regulator of doctors, that is to say, the General Medical Council. And what the Act certainly doesn't do, one wouldn't expect it to do, is to say anything about decisions the GMC might make about where it considers it appropriate to use a collective term for those it regulates. So when we're looking at the Padfield challenge, the starting point is to identify what the purpose of the Act is. And we say that is clearly what the purpose of the Act is, and using the term medical professionals in this limited way in good medical practice does not, certainly not run contrary to, certainly doesn't thwart the purpose for which those powers have been given to the General Medical Council. That's the answer to the Padfield challenge, as it's a proper Padfield challenge. But my learned friend has made a slightly different challenge, which she puts under the heading of Padfield. Can I just say, first of all, though, that we don't accept the criticism that the judge didn't properly address my learned friend's argument in relation to Padfield and the issue of medical professionals. And can I just give the court, please, the references in the judgment where it's clear that the judge was addressing her mind to the specific issue of medical professionals. It's paragraph 85, where the learned judge refers to addressing both issues in the challenge, that is to say the unitary guidance issue and the use of the term medical professionals. This is under ground 2, so clearly at the very start of the consideration of ground 2, the judge has reminded herself that this goes to both the issue of the unitary guidance and the use of the term medical professional. There's then reference to the argument on medical professionals in paragraph 91, where the learned judge summarises Miss Richards' argument. The fact that that's shorter than the page that's devoted to the unitary guidance issue simply reflected the fact that that was the weight of the argument below. The focus of this part, at least, of the challenge was on the unitary guidance point. Then in judgment paragraph 95, there's a summary 4 lines down, very bottom of page 76, as to the use of. The learned judge summarises the arguments on behalf of the General Medical Council. And then in the discussion, we see at paragraph 96 another reference to the fact that this matter is in issue. And at 102, the last 5 or 6 lines of paragraph 102 are devoted to specifically considering.
Yes, I think Ms Richards.
She did refer to those, but I just wanted to put it in context of where all the arguments have been summarised.
Yeah.
And it's a general principle when looking at a judgment below, particularly where the judge has expressly referred to those arguments, to accept that the judge must therefore have considered them in arriving at a conclusion, and we say that principle applies here. So that's that point. The second part of this challenge, of the ground 2 challenge, and I've tried to describe it in a way that my learned friend used, which is that she says another part of her Padfield challenge, or perhaps the main part now, is that there was flawed reasoning by the GMC, in that somehow the GMC considered itself bound to use the term medical professionals, even though there was no basis for that in the ultimate order. We say that's not a Padfield challenge, but in any event, I'm addressing it under this heading. And can I just make the following points? I'm really referring to the points, but I'm going to expand on them a bit in paragraph 63 of our skeleton. And we say that to say that the GMC did not bring its independent and expert judgment to bear on the question of what the appropriate collective term was is simply not a fair reading of the evidence. The GMC certainly did not regard itself as bound to adopt the term medical professionals because that's what the government proposed at one point. And there are a number of ways of getting into that. The first is, of course, and my learned friend accepted this morning, that the GMC used the term medical professionals to cover doctors and associates as long ago as 2020 in its corporate strategy, which you have in the supplementary bundle at pages 80 to 102, before any draft legislation.
So what was the page reference again?
Sorry, it's supplementary bundle 80 to 102. The actual references are on pages 82, 90 and 92.
So those are the references in the corporate strategy.
That's correct.
Yeah.
And they were before any draft legislation had been shared with the GMC. So we say it simply doesn't get off the ground to say the GMC was dictated to. I mean, it might be that that's really the public law ground, if the GMC somehow felt it didn't have a discretion in relation to this matter. Since it wasn't exercising any legal power, I don't think it would still get my learned friend home. Then, in early 2022, and here the chronology is rather important, the Department of Health and Social Care shared with the GMC a draft order in council that proposed, and this is again very important, proposed to repeal the Medical Act altogether and replace the Medical Act with a new framework by way of order governing the regulation of medical professionals, that is to say doctors, physician associates and anaesthesia associates. We've got that proposal in the bundle, and I am going to invite the court to look at this, please. It's in supplementary bundle, page 143. And if the court be good enough, please, to look there under the heading General, Citation, Commencement and Extent. This was the draft order. This order may be cited as the Medical Professions Order 2022. Mm-hmm. And then there's an interpretation section. And if you'd be good enough, please, my lord, to go over the page, about halfway down. Medical professional means A, medical practitioner, B, anaesthesia associate, or C, physician associate, and medical professions must be construed accordingly. Now, without going out of our course, as it were, we say that that is also, of course, relevant. The fact that that was the intention at the time must be relevant to the rationality challenge. The fact that it was considered that it would be appropriate in legislation to use the term medical professional to cover those three professions must be relevant to whether or not it was rational. It was a rational choice open to the GMC to do so, at least at that stage, and we say legitimate to continue to do so. Now, that more ambitious project, of course, we wouldn't be here if that had gone through, because it obviously would have had the express authorization of the legislation to use the term medical profession. It didn't go through, not because there was some Damascene conversion in the government. We don't have the documents in the bundle, but it was clearly stated subsequently in 2022, there's rather a lot going on, of course, in 2022, that there wasn't parliamentary time to put through as ambitious a reform as repealing the Medical Act and having one piece of legislation for both. It's in that context and with that chronology in mind that the court should look at the documents my own friend took the court to this morning. For example, 181, still in the same bundle, supplementary bundle. This is the guidance in relation to public consultation, which the GMC, as it were, set out what it was planning to do. Yeah. You've seen this. It begins at 181, and at 189 there's a particular passage my learned friend relies on. Can I just say this? One needs to look at the chronology. This was a consultation that ran from the 27th of April to the 20th of July 2022. It wasn't until September 2022, after it concluded, that the Department of Health and Social Security shared a draft of what became the order. That is to say, a more limited document which just dealt with the associated professions. So the chronology is very important in relation to these matters. And in any event, we say the reading that my learned friend put forward is not the natural reading of what's said in this document at page 189. Page 189, I've highlighted it, it's above, it's under style and application. It's the passage my learned friend took the court to before the shorter German. We've adopted the term medical professionals to describe all the professional groups we regulate. We, the GMC, have adopted. This is also the term that will be used in the legislation to bring PAs and AAs into regulation. Well, that was a perfectly legitimate point to make at the time, and it does not suggest, even then, that the GMC somehow regarded itself as blindly bound to adopt that approach and that kind of language. As I said, subsequently, on the 16th of September 2022, there was a draft of the AAPA order which only related to physician associates and anaesthesia associates and did not make provision for the repeal of the 1983 Act. But the Department of Health and Social Care did not say to the GMC that it was not proposing to proceed with broader reforms in relation to the Medical Act in due course. And again, as I've said, that's the context in which these other statements which were made. So we say it was independent because the GMC chose the term before there was any of the legislation. The fact that the legislation also used it was obviously relevant, and it was legitimate for the GMC to refer to that. And while that proposal was ongoing, it was legitimate for the GMC to say that they should use that. But as we see from the correspondence my learned friend referred to but didn't really show the court, and I'm sure that was simply to save time. There's no attempted criticism there, and I'm trying to cut out some of the extra materials I don't need to show the court as well. But my learned friend referred to two letters. There was a GMC letter to the BMA and a GMC letter to Anaesthesia United, who brought the other parallel challenge to scope of practice in relation to good medical practice, or rather the absence of scope of practice guidance from good medical practice. And I would, if I may, please like to show the court those. The first is the BMA letter, which is in the supplementary bundle at page 105. And above it, I wasn't proposing to take the court through that, but above that, there's the email from the BMA on at the bottom of page 103, which questions the use of terminology.
So 105, so these are the 2020-2021 exchanges.
Yes.
And so 105 is the second, I think, letter or communication from the BMA
That's
to the
correct.
GMC on the point. Yeah.
Yep, the first one is at 103. And the dates are important. So we're in January 2021, so a year and a half before the Department of Health and Social Care has said that it's not proposing to use the term. In other words, it was still assumed that they would be the terms that would be used in the legislation. But what we see from that BMA letter, 18th of February 2021, at page 105, sorry, that's the letter from the BMA. I do apologise.
Yeah.
I'm so sorry, my lord.
That's all right.
Underneath it, beginning at page 107, we have the response of the 2nd of March 2021.
Yeah.
And what you see there, even though we're right in that era, as it were, where everyone's expectation was that it would still be a new order covering both, talks about in the first paragraph, thank you for your letter, about the umbrella term we've used to describe doctors, physician associates and anaesthesia associates in our new corporate strategy. So it's about the fact that that was used in 2020, even before we'd seen the draft legislation. And I'm looking at the third paragraph. Perhaps the court will be good enough to read that.
Yeah.
We agree that PAs and AAs and then of the next paragraph, perhaps beginning 4 lines down, our communication and engagement activity will absolutely make that clear. PAs and AAs all have distinct and important parts to play in the UK's health system. They do not have primary medical qualifications. They are not doctors. We saw that guidance that was available on the internet at the time. And then finally on this page, we only plan to use the term medical professionals when appropriate to the circumstances, for example, referring to the collective professions we regulate, rather than listing out each individual role. Majority of our communications, including direct correspondence to patients and others about regulatory matters, will absolutely be tailored to refer to each profession individually. So when my learned friend was suggesting that that was some kind of change in the multi-professional glossary, that was always the GMC's position. And as we see, there's no reference there even to any decision by government and no suggestion that that is why the GMC had adopted that term of phrase. We also see it in the GMC letter to Anaesthetists United. That's in the same bundle, page 349. What's interesting about that in terms of the date is, of course, that this... 349 to 354. Oh, yes. This, of course, post-dates the Department of Health communicating to the GMC that it won't be producing an order which repeals the Medical Act and applies to all medical professionals. And we see reference in it to the GMC's overarching objective on the first page there, promoting and maintaining public confidence. We agree that patients must always be clear about who is treating them. Every healthcare professional has a duty to clearly explain their role and drawing out differences of knowledge and training and so on. And the specific guidance that will be included in relation to physician associates describing their titles and introductions. There's a reference then to the Faculty of Physician Associates' own guidance, which we saw was referred to in the extracts from the web pages. Standardised way of using the PA title highlights the importance of explaining it to patients and to colleagues. And then under use of terminology, you'll see a reference there to the matters that are specifically raised in relation to the terms medical professionals. But the point is, and the court can read those, perhaps those two paragraphs, if it would be good enough, beginning, our legislation sets out the legally protected title, and the paragraph which follows, beginning, on occasion we use medical professionals.
Yeah.
So again, no reference to the fact that it had been the government's intention or the Department of Health's intention to use that term in the legislation. No sense that the GMC regarded itself as bound by that. And the GMC obviously didn't consider itself bound by that, because you can see from the second paragraph that they considered alternatives, such as using the term registrants. And that's what the judge was referring to in her determination at judgment 95 below, when she said that she was satisfied that the term medical professionals was not just a hangover from abandoned legislation. It's the very top line of paragraph 95 on page 77. We say that when you look at the evidence fairly, it's perfectly clear that that's the case. So that's what those documents show. But of course, if the GMC had regarded itself as bound to use the term medical professionals anyway, it's difficult to see why the GMC would have embarked on that long period of consultation that it did, through the public consultation that we've seen, the advisory forum, the various groups that got together in order to discuss a number of matters, including these specific matters relating to nomenclature. And that's all summarised in the learned judge's judgment. I don't propose to take the court through the references now, but the GMC was actively consulting on whether or not it was appropriate to use the term medical professionals. And it wouldn't have done that. There would have been no reason for it to do that had it considered itself bound in some way to have adopted that line. So that's, we say, sufficient to dispose of the point that the GMC regarded itself somehow as bound to adopt that term. It clearly didn't, and it was its own determination. I've alluded to irrationality as part of ground 2 already. Mm-hmm. Very difficult, we say, for my learned friend to get that off the ground, given that that was the term chosen by the Department of Health initially when it proposed that is what it was going to do in the area. It cannot be disputed that associates are professionals. It cannot be disputed that they are medical professionals and provide medical services. Indeed, the AAPA, I won't take the court there, but it's in Schedule 3, Para 2, brackets 1, brackets D, brackets Roman 1, and it's on page 280, refers to the provision of medical services by physician associates and anaesthesia associates.
Well, I don't think we have to worry about that, because the judge found at paragraph 83 that the description was a fair one, and that's not part of the appeal. So
Thank you.
I think that point is...
All right, thank you, Rob. So we say that's enough to dispose of ground 2. Ground 3, we come to the question of delay.
Yeah.
Now, having said I'm keen to avoid taxonomical disputes and so on, there is one here, of course, about precisely what the relevance is of what the judge decided in the sense of granting permission but deciding not to give an extension of time. There is a way round it, and my Lord Justice Coulson identified it, which is that it's clear from section 31(6) of the Senior Courts Act 1981 that if the court considers that the claim has not been issued promptly and in any event within 3 months, it can either refuse permission for making the application or refuse any relief sought on the application if it considers the granting of relief would be likely to cause substantial hardship too. And one could say it doesn't make any difference. Now, obviously that didn't arise in this case because the claim failed on its merits, but it would have been legitimate for the judge to treat the delay as being a reason for not granting any kind of remedy had she got to that stage, any relief, as it were, that was granted in the application. However, that's not the neatest way of dealing with it. That's a way of getting around the difficulty. And we would say, as a matter of principle, the judge, with respect, ought to have decided, once she decided that there were no good grounds to extend time, that permission was refused on the basis of delay.
Because it was a rolled up hearing.
That's the point, my lord. I think that's the difficulty. So what it was ordered to be a rolled up hearing by Mrs. Justice Lang, that came before Mrs. Justice Lambert. We all agreed that we would deal with the substance of the matter, of the arguments, in order that the judge could determine arguability. And that's why I think the discussion of delay wound up at the end, and what may have led to the judge perhaps meaning when she said, I grant permission, I accept it's arguable, and there was no dispute about the standing of the BMA. So I accept
it's arguable, and I've just heard all the argument.
Yeah. But of course, we don't have the right of appeal against the grant of permission.
No.
So in case it's said against us, well, GMC should have challenged that if they thought it was the wrong way around.
I understand.
We don't have the right to do that. What we say is, so that's...
The trouble is that,
Yep.
I mean, I'm sure it will be water under the bridge, but because the procedural point came at the end, it's sort of slightly, it's a slightly awkward fit. But of course, one of the reasons it might be said that the procedural point comes at an end here is, according to Maharaj, one of the things you take into account are the merits. And you can't do that until you've heard it argued. So it's all, anyway.
Yes.
As I say, I'm sure I'll find a way of ironing it out and dealing with the substantive points that arise on ground 3.
It's fair to say, though, that on that Maharaj point, it's true in permission applications, which can be obviously generally determined on the papers. One would expect a claimant, if they were applying late, to make very clear, as it were, what their best points were and emphasise that the merits were strong. So it's not the case that that matter can only be considered after you've had a rolled up hearing.
I
know your lordship wasn't suggesting that.
I follow that.
Yeah. Thank you very much, Ronald. So can I turn to the substance of
sure.
the decision on delay? The first point, of course, is to determine, we know when time stopped running because we know when the claim form was issued, and that was on the 5th of July 2024. There's a dispute about when the time started to run.
Yeah.
The rules on this are very clear. The authorities on this are very clear. So clear we've only put one authority in on it, and it's the case of Presvac, but it's the case that's constantly cited on the matter. I'm not inviting the court to turn it up. Tab 12 of the authorities bundle, page 507. It's entirely clear from Presvac that time begins to run from the date at which the decision is made, not when it's communicated. And the way that you deal with the fact that that may cause an injustice is because that's the date at which they found out about it is relevant to whether or not you grant time. But in order, presumably, to avoid disputes about, well, when precisely did you find out, the starting point for time running in judicial review claims is always the date the decision was made. Now, the fact that that was a draft doesn't help my learned friend, because it was a draft that was in all material respects, and in this respect, which is the only one that matters, used the term medical professionals in the same way as the final guidance, which appeared later on in August of 23. Sorry, August of 20, yes. So that, we say, doesn't assist my own friend. But even if the judge was wrong about that, and I think this is the point that the court was exploring with my learned friend before the short adjournment, the BMA accepts that time must begin to run from when it was sent Good Medical Practice and when it was published in August 2023.
Yeah.
And even then, there is a very, very substantial period of delay, which cannot be regarded as issuing promptly and therefore requires explanation from the BMA.
Yeah.
What we don't see in this case, and if the BMA really were of the view that, well, we're not sure even if associates are going to be regulated by the GMC, and we want to see if there are further iterations of good medical practice, and we want to wait until associates are regulated by the GMC, they could have sent a shield letter. It's very common in the administrative court now, as I'm sure the court's aware. You send a shield letter to the defendant saying, we think we've got a legitimate ground of challenge here, this is what we say it is, but it will all be academic if Parliament doesn't introduce these provisions rendering associates subject to GMC regulation. So will you offer as an undertaking in this correspondence that you won't take the time point against us? Now, that doesn't prevent the court from saying it's still not been issued promptly, because obviously the parties can't agree their way out of the time limits in Part 54. But it is relevant. The authorities say it's relevant to how you decide whether or not to grant an extension of time if the defendant has said, we won't take a time point against you. BMA didn't do that. Instead, they've just relied on these matters that I've described, and if I may, I'll try and explain why they're not good reasons. We say, and again it's a point that's been addressed by the court, of course you read the refusal of permission to appeal, we've got it at page 85 of the core bundle, along with the judgment. It's clear there that when the learned judge said no explanation, she must have been referring to no good explanation, because she says there was no good reason for the delay in the refusal of permission to appeal.
Well, as my lord reminded Miss Richards, there are parts of the judgment which talk about the delays, although I think it's fair to say that most of that is concerned with the period up to, for the sake of this argument, we'll say the trigger date was August.
Yes.
Just for the purpose of this discussion, I think effectively the objections from the BMA started to be made again after a long period of silence when there was the consultation on the order.
Yes.
I mean, that's my understanding, that's my feel for the correspondence.
Yes.
And so I think Ms. Richards' emphasis is, yes, well, there may be stuff about the events up to August, but the judge doesn't deal in, certainly not in any detail, with the good reasons for an extension, which should obviously then in the next period. I think that, in short summary, is the battleground between you.
Yes, well, and I think that's my understanding of what's been said as well. But again, if we're right to read when the judge says there's not been an adequate explanation for the delay, when the judge was addressing that point from the Maharaj case in paragraph 122 expressly, then we must assume, given that all of these points were advanced on behalf of the BMA by my learned friend, that the judge did not find any of them persuasive, and she didn't need to deal with them each in turn. We would say, in any event, that she was right to do so, for the following reasons. If we look at the grounds that are said to justify the delay, I've dealt with one, which was it wasn't notified to the BMA, but that just gets us to August, of course. As regards the point about it wasn't clear that the GMC would become the regulator, well, after there'd been the consultation about the order, there was no indication from the government, and indeed that had been the case since early 2022. In fact, 2019, the government had indicated that the GMC would be the regulator of the associate professions as well. Once you've had a consultation on the draft order, that removes most doubt. It doesn't mean, of course, that it will necessarily become law, but it makes it highly likely, and it makes it particularly highly likely in a case where there are no indications from the Department of Health of any other course of action being pursued. So we say it's not appropriate. If your challenge is not to the order, if they've been challenging the order, that would have been fine. But if they're not, they're challenging a GMC document that was made many months before the order came into force. And so we say that's not a good reason.
I think the expression the judges use, and this is completely from memory, I think the judges use it was never in serious doubt.
Yes.
That I think is the expression.
Well, there was certainly no evidence to suggest that it wasn't the government's intention to follow through on placing the associate professions subject to GMC regulation.
Yeah.
And we say it's not fair to say that the judge didn't refer to sufficient public interest to extend time, because again, paragraph 122 of her judgment, she says there was no evidence that, this is at the very bottom of 122, there was no evidence that serious patient safety concerns are the result of the decisions under challenge. That must be in both the unitary guidance and the use of medical professionals. That leaves the last point of the amendment to good medical practice. Again, that can't be relied upon. The fact that there was a December 2024 iteration, that can't be relied upon, because although everyone agreed that it was sensible for the purposes of the argument to have regard to the terms of the December 2024 document, it was the case, and remains the case now, that the challenge was to the previous version, because that was the version that was in force at the time that the judicial review was launched. And your lordship referred to the sort of Wild West, or the rolling judicial review, as it were, of a...
It's the administrative court. I recognise that there's a certain amount of fluidity.
Yes, and of course the administrative court guide in particular is very clear that it is against rolling judicial reviews. The appropriate practice is to withdraw the claim if a decision has been superseded, and then bring a fresh claim against that. The reason that wasn't considered proportionate in this case, and the GMC didn't advocate that, and this is why, my lord, was because in relevant respects, that is to say the use of the term medical professionals, although there were slightly fewer uses of the term medical professionals in the December 2024 one, it obviously still used those terms. And it was felt that it would be somewhat unreal and cause undue delay to say there has to be a new judicial review that's issued. So
on the terminology point, the only difference in reality is that what was a footnote then becomes part of the text, because by then the order had been made.
Yes, and also there are, I think, two places where doctors, physician associates and anaesthesia associates are used instead of medical professionals.
Okay, fine.
So it's that.
Yeah,
they're the main differences.
Yeah.
That was why regardless had to. But that reinforces our point, we say, which is, look, the substance of the challenge as a matter of law was what was in the judicial review claim form, and that was this earlier version which the BMA had, even on its own case, from the earlier date in August.
Yeah.
So that's what we say. In other words, we say the judge was right to refuse an extension of time. The logic of that, we say, is, even if the court were persuaded by my own friend's arguments, that would still be a reason for which this claim should fail. Those are my submissions, my lord. Thank you very much.
Thank you very much, Mr. Hare. Yes, so, Ms. Richards, I think the ground has been well and truly trampled, and I repeat the point I made before. We are extremely grateful for the efficient way these submissions have been addressed, and any comments that I've made about the Wild West clearly does not apply to the preparation and advocacy in this case. Now, you have the right to reply. I'm sure you have some points in reply. Do you want 5 minutes now, or are you quite content to bang through them?
Quite content to bang through them, my lord.
Sometimes when I say 5 minutes, the advocate then says, well, that might help me to make it shorter, but you're obviously quite happy to bang through them in any
I am.
event.
My lord, all I will say is, I note my lord's liking for headings. I can't promise that as a reply I'll have clear headings.
No.
But I'm only going to deal with points that have been made in all the
Fine,
submissions.
but what I'll do then is number them. So I mean, leave that to me, but if I get confused, I'll raise my confusion.
Well, I'm actually going to deal with the last point first.
Fine.
The question of delay and extension of time, not least because I don't have very much to say. Just from my lord's notes, in the pleadings in the court below, there wasn't a formal amendment to challenge the December guidance in the sense that there wasn't a underlined reiteration of the statement of facts and grounds. But in our reply to the defendant's grounds, no need to look at it, it's in supplemental bundle, page 471, paragraph 3, we said, court, please treat this as a challenge to both sets of guidance. And then by the time we actually had the hearing in practice, we was focused on the December guidance. Yeah. And there was no demur from that by the GMC. In fact, I think its detailed grounds indeed focused on it on the December version. Not, of course, if we'd had the sheriff with their procedural hat on and withdrawn the claim and reissued, it would have been in time. And so we do say that the December guidance is a not insignificant factor in terms of considering whether there is good reason to extend time. Well, just then very briefly on the question of time running from April, and I'm appreciating, of course, that only accounts for a period of time. There's an air of unreality to a submission which says something that's not final, it's still a draft, it might actually turn out to be the version that's ultimately promulgated, but not final, and that nobody outside of the defendant knows about. No challenge could be brought to such a document. It cannot be brought until it's received as a matter of practicality. So there is no, I say, of unreality there.
Which is why, when putting the point to Mr. Hare, I said, let's take, for the sake of argument, August, because it doesn't matter, in one sense, whether it's April, but there's a almost automatic extension. Sorry, April, and you take an automatic extension to August because you didn't know about it and it was a draft, or you trigger it in August. I think, but ultimately that's not likely to make a difference.
No, and the only other point in relation to my learned friend's oral submissions, because I think anything else I say would just be a repetition of my earlier submissions, is the point about it not being no indication from the Department of Health that they would be changing their course in terms of the identification of the GMC as regulator. No, that's perfectly fair comment in relation to the Department of Health, but the whole point of Parliament is Parliament decides. And there was a matter that was a live matter before Parliament. There was no order regulating, appointing the GMC as regulator, and that was a matter for active consideration by Parliament. Those, however, are the points in relation to ground 3.
Yeah.
So I'm going to turn back to the beginning and deal with some of my learned friends' oral submissions about the substance of the position. There've been a number of references to a concept of of a legal hook, legal framework. Good medical practice is statutory in its origin. It is not non-statutory guidance, as I think is the case in some of the authorities. It is expressly guidance that the General Medical Council is empowered to issue in relation to doctors under Section 35 of the 1983 Act. So there's a clear legal statutory origin for that guidance, and then there are equivalent provisions in the 2024 order. So this is guidance issued in the exercise of statutory powers, and so that very fact brings, in my respectful submission, the whole statutory frameworks into play. And if, by way of example, instead of using medical professionals, the terminology in good medical practice was medical practitioners, we say that would be a clear misdirection of law and a clear misstatement of law.
Isn't that the point, though?
Because my lord, what we say is you can attach the same significance to medical professionals as medical practitioners. Because when one looks at sections 1 and sections 35 of the Act, and section 35 I've just alluded to its importance because it's the source of the power to issue the guidance, that is about the provision of advice for members of the medical profession. And so the very power that's being relied upon is a power that is concerned with the medical profession. And then in pursuit of the overarching objective, which again is concerned with the medical profession. And so, for the reasons I've given, and I don't want to go over, and my lords will accept or reject the arguments, we say that medical professionals absolutely must mean and can only mean in the context with which we're concerned, which is a specific statutory context, must and can only mean medical profession, members of the medical profession, which in turn can only mean medical practitioners. Yeah. But I was dealing with then my learned friends. I think his first point of 5, I think, was common ground. That the grounds for judicial review are not hermetically sealed. My learned friend's second point, again a measure of agreement, we're not on all fours with RA, and we absolutely, obviously endorse that. But what my learned friend then went on to say is that the fact that good medical practice is different from the kind of practice in issue in RA and the BF Eritrea case points in the GMC's favour. I say not for 2 reasons. I say, first of all, if anything, it points against the GMC for the very reason I've just given, that this is statutory guidance issued in the context of powers under pieces of legislation that deal specifically with, on the one hand, a medical profession, and on the other hand, 2 associate professions, rather than being non-statutory guidance. But secondly, if anything, that's a neutral point at best, to say that this is not the same kind of guidance as was in issue in the Supreme Court cases. There was some reference in my learned friend's submissions, and it may be that there's no great disagreement between us here, as to who is the intended audience of good medical practice. We say, and I don't think my learned friend necessarily demurred from this, that the audience is not just doctors and associate anaesthesia and physician associates, although they are clearly to whom it is centrally directed. But this is a public-facing document. This isn't a page on a website. This is the statutory document promulgated by the GMC as being its central guidance to doctors, PAs and AAs. And it clearly has a public role. The consultation undertaken by the GMC wasn't solely with the professions. It was a consultation that involved the public. Guidance of this kind is intended to be understood by and accessible to the public. And so we say, important to understand then the overarching objective of public protection if you're issuing guidance that is going to be read by the public as well as by doctors and associates, it's absolutely fundamental that the legal position is accurate in all material respects. My learned friend then suggested there were a number of distinctions, in particular by reference to Gillick. He said that good medical practice isn't about legal obligations but ethical duties. In my submission, nothing turns on that. In fact, it's about both. And if one goes to Core Bundle, page 294, very top sentence, you'll see it absolutely is about both legal and ethical duties.
294.
Yeah, top of page 294. But in any event, the central point is the fact that it's not about specifically what legal parameters should, for example, drive doctors in their interactions with patients is really nothing to the point. What we see from this guidance, the passage you've already seen, but then the very bottom of that same page, we see the phrase about promoting and maintaining public confidence in the medical professions. The reference to promoting and maintaining public confidence is reference obviously to the statutory overarching objectives. But the statutory overarching objective in the Medical Act makes no reference to there being medical professions in the plural. So my learned friend then suggested that there's some significance to the fact that the references to medical professionals appear in the introductory sections rather than in the parts, the numbered paragraphs which say you must do this, you must do that. We say that's nothing to the point. What this guidance does is tell, first of all, the public that associates are medical professionals, members of a medical profession.
What this guidance does is tell the public that this is what is to be expected from medical professionals.
Forgive me, my lord.
I mean, we need to keep
yes.
a firm eye on that. I mean, I appreciate that there's part of this challenge is, amongst other things, you say it also says.
Yes.
But
your lordship's absolutely right. The relevant parts I'm relying on is the way I should have expressed it, my lord, rather than the guidance as a whole, because your lordship is absolutely right to pull me up in relation to the bigger parts of the guidance. But my lord, it's absolutely what this guidance has the effect of doing, in my submission absolutely clearly, is saying to registrants, associate registrants, that they can call themselves medical professionals and that they can say that they are members of a medical profession. And my learned friend's suggestion that
just on that first point, they can call themselves medical professionals. The judge said that was entirely fair. And that's not a part of the appeal.
Well,
the judge said that was an accurate description.
Well, my lord, it is part of our appeal that medical.
We don't appeal paragraph 83 of her judgment and that finding that it was a fair description.
Well, my lord, no, you're right. We haven't specifically appealed that part of her judgment. But what we are saying is there is.
I understand the point about the equation with the medical practitioners, and I understand the point about the medical profession. But the judge found that that was a fair description, that the associates are medical professionals.
Well, my lord, let me put it in a different way.
You have to say that they, as a result of the terminology, they can call themselves medical practitioners.
My lord, I say that as a result, I say I don't have to go that far, but I do say that the.
What do you say then?
So, I say that this entitles them to say that they are members of a medical profession in circumstances where the legislation identifies only a single medical profession, that of doctors. And so that
I
then...
can't help feeling that point gets to a number of angels on the end of a pin.
Oh, my lord.
They can say that they are members of the medical profession. And you say that is...
a statutory term of art.
Yeah, I understand that.
Medical
But you say that's the mischief. Because you say you don't have to go as far as to say they can call themselves medical practitioners.
My lord, yes. So the link with medical practitioners is that once you're able to describe yourself as a member of a medical profession, you are effectively describing yourself as a medical practitioner, not explicitly, but that's what the statute, the 1983 Act, and the members of the medical profession in the 1983 Act are medical practitioners.
Yeah, well, I understand the argument.
My lord, I'd say there's nothing in paragraph 82 in our submission which undermines that. 82 is page 314 of the bundle.
Yeah.
Because none of that undermines the terminology that the GMC has used in the good medical practice, terminology that registrants must therefore plainly be at liberty to use. Saying that you must introduce yourself to patients and explain your role, well, that can be, I'm a medical professional, I'm going to diagnose you, I'm going to assess you, I'm going to do the following tests. That would be perfectly compliant with paragraph 82. So 82, again, it is in my respectful submission, nothing to the point. Malone made a number of submissions in relation to Gillick. Don't ask my lords to turn to the detailed discussion in relation to Gillick. The fact that there were specific legal obligations, duties, prohibitions in issue in Gillick is, again, doesn't in my respectful submission assist in one way or another with the arguments in the present case. Particularly if it's accepted, as my learned friend I think appeared to, that RA isn't a straight jacket. Legal hook clearly isn't a legal term of art, but if we need to look for a hook, we have it in my respectful submission in the statutory distinctions between members of the medical profession, members of the associate professions, and in section 49 for all the reasons already given. And I won't go back to the submissions on section 49, but for the reasons set out in our written arguments, and I think an answer to a question by my Lord or Justice Cobb, we say section 49 is rather wider than my learned friend's submissions would suggest. The other issue in relation to RA, which does require me very briefly to take you back to that, is paragraph 38. And this relates now to my learned friend's reliance upon the use of the word induce in paragraph 46 of RA. I draw to my Lord's attention paragraph 38, which in fact uses the terminology of authorise or approve. And I don't think reading the judgment as a whole that there's any suggestion that their lordships, by using the word induce in paragraph 46, were suggesting that the formulation in paragraph 38 of Gillick was in any material respect incorrect. My learned friend did refer to a number of points he drew from Gillick, I think it's paragraph 34 of the judgment, about how the court should approach guidance. Reading it objectively, we don't dissent from that. Not required to imagine that people might misread it. Again, we don't dissent from that. We say that's not any part of our argument. And then he flagged up that it's inappropriate for the court to be drawn into a revising role. We say that's not our case, but nor is it a logical consequence of our arguments being correct. And then, my lord, I think in relation to my learned friend's other arguments regarding RA, I don't think there's anything that would be anything other than repetition of my previous submissions. So can I move then relatively briefly to Padfield?
Yeah.
My learned friend flagged up the terminology thwart or run counter in Padfield. I just remind my lords of the slightly different formulation by Lord Justice Laws in the Hall's case. It's the passage I took my lords to earlier. So it's page 542 of the bundle, where Lord Justice Laws talks about, first of all, identifying the purpose, and then was the purpose in the particular measure calculated to promote the policy of the Act. So calculated to promote, in my respectful submission, rather than thwart or run counter, is a perfectly appropriate terminology. My learned friend's invitation to you on the Padfield arguments was essentially to look at it in a very on a micro level and say, well, this is guidance which overall achieves the objective or is aimed at the objective of protecting public safety. In my respectful submission, the issue needs to be looked at by reference to the dispute in the present case and the terminology in relation to medical professionals and medical profession. And the question must be, what is the purpose of using that? And here the Padfield and the rationality arguments are closely linked. What is the reasoning? What was the GMC seeking to achieve? And that leads me, I think, to what my learned friend dealt with in terms of the documentation. I note my learned friend made no submission whatsoever about that part of the GMC's decision-making documents that talked about it not being in our gift to change. If that isn't regarding themselves as bound by the statutory description, or at the very least a clear decision to adhere to what was going to be the statutory label, then I don't know what is. My learned friend rightly reminded you of the importance of chronology, and I want to do the same. He took you to the letters, the exchange of letters about the corporate strategy in early 2021. That was specifically about a corporate strategy, a document that doesn't have statutory underpinning or statutory force. It's not Section 35 guidance. Whatever disagreement there might have been between the BMA and the GMC about how terminology was used in the corporate strategies is frankly neither here nor there. What matters...
I thought that was a point in your favour, because after that we don't get any objections by the BMA for 3 years. So I thought it was in your favour that there were some letters in 2020-21 which were objecting. But if it's neither here nor there, which I don't disagree with, but okay, so that's that bit of the chronology then.
Well, it's neither here nor there in my submission in understanding what the GMC's decision-making process was specifically in relation to good medical practice. We have only a limited numbers of contemporaneous materials relating to the GMC's decision-making process. It's specifically in relation to good medical practice. Those materials are all one way. And again, drawing on the principles of procedural rigour, looking at the contemporaneous materials, not any letters written to any statistician licence in 2024, is important. And so we have those early discussions about corporate strategy, but when we get to the chronology in relation to good medical practice and what terminology is going to be used there, the only reason advanced is the reason of tying it to the legislation. And then my learned friend leaps forward, providing no reference whatsoever to any contemporaneous material, to that letter in 2024 written in response to an anaesthetist United saying, oh, well, we think it's a good phrase, or we'll only use it in certain limited respects. That wasn't what was being said by the GMC in the consultation process. My learned friend said if the GMC regarded itself as bound to use that phrase, and again, not making any submission about the not in our gift, He said, why have a long period of consultation? But you've only got the pages in the documents that deal with the issues with which this appeal is concerned. That was a consultation on a whole range of different issues in relation to good medical practice, which had to be consulted on. The fact that the pages that deal with good medical practice are as clear as they are in relation to the GMC's reasoning being tied to the statutory definition doesn't, in my respectful submission, assist my learned friend. Rationality, then, finally. My learned friend suggested that rationality difficult to establish because the DHSC, in part, he said, clearly regarded medical professionals as an appropriate label, and therefore how can it be said to be irrational? Can I just flag up in the authorities, sorry, in the supplementary bundle, behind tab 15, page 177, this is a document that accompanied the sharing of the order, which is at the previous tab that my learned friend took you to. And I just invite your attention to what's said.
Sorry, which order?
Oh, sorry.
The order that then didn't happen.
Exactly. The order that used the phrase medical professions and medical professionals that was never enacted.
With. Yeah.
And so the document starting on page 177 accompanies.
So who's the author of this?
I'm so sorry, because we've only put in the relevant extract. I'm not sure I know the answer to that. It was either the GMC or the DHSC. DHSC. It was provided to the GMC.
Right, so this is the department, yeah.
Sorry, yes. I'm afraid I'm taking it solely from the index, and we can check that. But my understanding is this was from the DHSC.
Yeah.
And you will see under the heading medical professional, it says that covers the professions that we regulated. We note that further work may be required around the definition of medical professional. We intend to undertake a legal review of the full order to consider the consistency and accuracy of when the terms medical professional, medical practitioners and persons have been used. And we've no idea if that review was ever undertaken. All we know is
well, that's what we're doing.
Yes.
Save some salaries of some civil servants. Ask the Court of Appeal to do it.
Yes. Well, we've no idea whether the DHSC undertook any such review. We just know that when they introduced the 2024 order, it did not use this phrase. There may be all sorts of reasons why it didn't, but what my learned friend can't do is rely upon it as somehow supporting the rationality of the GMC's position. In any event, as I hope both our written and my earlier oral submissions made clear, our rationality case is not pinned on what's customarily or often now referred to as outcome rationality, diversity. It's pinned on the decision-making process. And I took my lords to the citation from the Law Society and Lord Chancellor case, which my lords will have from the earlier submissions, and it's in our skeleton in any event. But it's the point about there being logical flaws or failures to take into account relevant considerations and so on. And in that respect, I note my learned friend's submissions did not even touch on the submissions I made in relation to the medical terminology guide, the document that was not before the judge, which for all the reasons I gave earlier, wholly undermines any claim to attempt to say that this was done for reasons of clarity, accessibility and readability, which was the judge's finding. My lords, if I might just turn my back.
Of course.
Lord, thank you.
No, thank you very much. Mr. Bukhara, it does look as if you're going to be denied the opportunity to make submissions about the fresh evidence, because we've considered some of the fresh evidence and we'll consider that in our judgment. So I'm sorry to deprive you of that opportunity. Thank you both very much. Thank you to all those behind you. That was an extremely efficient and, if I may say so, thoroughly enjoyable day. You will be unsurprised to learn not be now embarking on a extempore set of judgments. We will reserve our judgments and you'll get them in due course. When you get the draft judgments, they're obviously an opportunity to comment on our grammar and any obvious factual errors, but it's not an opportunity to re-argue the case. As you know, the draft judgment is what it says. It is a draft. It's covered by all the rules that relate to draft judgments, and so please ensure that it doesn't go beyond those people who have been identified as recipients of the draft judgment, because to do so is a contempt of court. I asked my clerk when we came in this afternoon whether he had a list. He had a list of counsel. It may be, therefore, that the parties will need to identify to my clerk, please, those other people who should receive the draft. Can I ask, in this case in particular, can I ask that that list be kept as short as possible on either side? That way there's less risk of things going wrong. When we get your comments back, we will then finalise the judgment. At the same time, we would ask you to agree, if at all possible, the order consequent upon the judgment. If that proves impossible, if there are 1 or 2 points that can't be agreed, the best thing to do is to produce a draft with the 2 alternate versions, and then very short, and I mean very short, written submissions on the points on which you disagree, and then we can resolve those amongst ourselves. There will be no need for attendance thereafter at the hand down of the judgment and the finalisation of the order. Thank you all very much.